Sorry. Sorry, it's the first day of sitting, so they want me to approve. Okay, well, we'll see what happens. Good morning.
Good morning.
Could you help us with the pronunciation of your name?
My lord, yes, Mr. Loof, thank you.
Loof.
Yes.
Very good.
May it please the court, I appear with my learned friend Mr. Field on behalf of the appellants. The respondent, Ms. Okunola, appears in person. My learned friend Mr. Donmall appears appointed by the Attorney General as advocate to the court.
Yes.
May I briefly address speaking times? We have conferred, the parties and Mr. Donmall, and subject obviously to any indications and directions from the court, what we have provisionally planned is that I will try to confine my at least primary submissions to an hour and a half. I understand that Ms. Okunola will rely on written submissions and then be available to answer any questions that the court may have of her. Mr. Donmall informs me that he will need about an hour. I think that this, at least provisional schedule, should leave ample time for additional issues such as, for instance, a brief reply from me should the need arise, and margin for any final matters that may be addressed by the court at the end of the hearing.
Good. Let's see how it goes.
So subject to that, if I may begin by giving a very brief introduction to the parties and the background to the proceedings generally.
Do we need that? We've read the judgment of Mrs. Justice Hill in the main case, all of us, I think. We've read the judgment below. We've read all the papers before us. I don't think we need that sort of introduction.
Very well.
The issue with this case is very difficult, isn't it, Mr. Loof? There are many more issues than appear in any of the skeleton arguments.
I hope that that gap has been at least somewhat closed by the additional submissions that the court has
Not yet, I think,
listed.
is the answer.
Yes, so hopefully in dealing with the fundamental issue on this appeal, which is in my submission, whether the court's inherent jurisdiction to issue injunctions extends to making orders prohibiting a party from engaging with another party's legal representatives in ways which interfere with the good conduct of those proceedings before the court. And in addressing that, I propose to deal with these issues in 4 sections. The first section will address where we contend that the learned judge erred in relation to her reliance on the so-called the Siskina doctrine. The second section will then deal with the soundness, as we would argue, of the jurisdictional basis relied upon by the appellants in seeking the injunction. The third section, I propose to address the potential alternative remedies, as my Lord Justice Warby put to the parties originally, and which is the subject of the supplementary skeleton argument, which is in the core bundle at tab 4. And then the fourth section is the question that my Lord Master of the Rolls put to us on Friday, which, assuming that the jurisdiction that we contend for exists, how should the court approach this application in light of any right of the respondent under Article 10 of the European Convention to freedom of expression? And that is the subject of written submission that we submitted yesterday morning. And so, my lords, my lady, I plan to address the court's questions from yesterday in the context or where they appear appropriate in that outline. And finally, there is a fifth section, which is, I'm slightly in the court's hands in terms of when you would like me to deal with it, and that is submissions on the continuing utility of the order in the event that you're with me, and that you're with me on the jurisdictional point, and that you're minded to consider making the order. So that would be a fifth section, should the need arise. May I begin then with the first section to address the so-called Siskina doctrine or the cause of action rule relied upon by the learned judge. And if I may begin by taking your lordships, my lady, to the Supreme Court's judgment in Wolverhampton, and that's in the authorities bundle, tab 25, and where I propose to begin is at page 659, paragraph 43.
Sorry, let's start that again. I'm just noting that down. So help again with where it is.
So the authorities bundle,
Which tab?
I've got lots of authority.
tab 25.
I don't have one.
Electronically, we've got it in 4 bits, which is
Right.
so. I'm not quite sure where.
It will be the final bit, I would have assumed, in that.
Yeah.
It might be better for us just to get Wolverhampton up. It's not in my authorities bundle. The bundles are crazy. Can we make sure in future we have one authorities bundle, not 4 electronic bundles? That just makes it impossible.
Well, yes.
I think I can find it.
So can you give us a page?
Yes, in the report it's page 1010 at letter A. It's right at the top of that page, paragraph 43.
Yeah, 632 of the bundle, I think. That's what it is. Paragraph. Navigation is going to be quite difficult. Could you just give us the paragraph again?
Yes, it's paragraph 43, which
Thank you.
begins. Yeah.
Yes, words are quite useful to find, but I can find 43.
I'm grateful. There, having considered the Siskina and what was effectively, from a historical perspective, a swift rowing back from it, and then ending with the Privy Council advice in broad idea, what the Supreme Court says is that it is now well established that the grant of injunctive relief is not always conditional on the existence of a cause of action. And then later on in the judgment, at paragraph 153, so now we're at page 1041 of the report. It is page 690 of the authorities bundle as printed in the lower right-hand corner.
Could somebody send me the bundle in which this case is to be found? I haven't got it. I mean, it's could it be sent electronically immediately, and then I can look at it? I'm looking at Wolverhampton. I've got a copy of it, but it would be helpful to have the bundle that you're referring to. I've got 4 bundles and a new one sent this morning. I have not got this one with tab 25. I've got Wolverhampton. I can get to paragraph 153, but you know, we must have some.
Well, I think the difficulty was, from a practical perspective, is that for the purposes of CE file lodging, it had to be split into 4 sections. We will make sure that the bundle is sent to your lords and my ladies.
Well, if it's 4 sections, the 4th section, my 4th section finishes at tab 18 with quadrilla.
Likewise.
I can only
Anyway,
apologise.
I mean, just cutting to the chase
Yes.
here, we accept that Wolverhampton is the authority.
Yes.
We accept, I mean, subject to any argument that Ms. Okunola may address, we accept that Siskina is no longer good law.
Yeah.
So how much time do we need to spend on that?
Well, the point I was going to make is that, obviously, in light of these developments, I wasn't going to address this more than to take your lordships to this authority. There are, however, 2 points of relevance to the appellant's arguments more generally, which I would like to emphasise.
Yes.
And the first one is that whatever its status currently, and your lordship has indicated that it's no longer good law, even on its own terms, it should never have been a bar to this application.
Does that matter now?
Well, it does, because it has to do with the basis upon which the learned judge actually applied and construed the application. If I can, it may not be necessary, but take your lordships to the passages in the Siskina and how it was.
I mean, the Siskina has been completely swept away.
Yes.
By Lord Legate's judgment in Convoy Collateral. And going back to it now is really an incredible historical digging exercise, which I would regard as unnecessary. However, the whole argument in this case seems to have ignored even more modern authority than Wolverhampton, because Abbasi would seem to me to be a critical Supreme Court decision, which this court, this very constitution, construed and explained in PMC only in August. None of these cases are before us. I mean, Abbasi is critical because it says in terms that if you've got a domestic cause of action, you should be using it, right? And what's happened here is that you've asked for an injunction using subjective words, belittle, demean. I don't know what they mean in law, when you've got a perfectly good statute that says you're not allowed to harass people. Now, the question is, what were you doing? Making an application in the name of a company for an injunction to stop words being used, with using a form of words which have never been seen to my knowledge in an injunction, when you had a perfectly good cause of action in harassment. Now, you may say, and I accept, CPMC, that of course you can get an injunction to protect the integrity of the legal process. But question, should you get such an injunction when you've got a perfectly good cause of action in harassment? And this is what has to be addressed in this case, because whilst Mrs. Justice Hill expressed herself in the terms of the Siskina, her gut obviously was, her gut reaction was, this is the wrong process.
So let me then, my lord, address the very issue that you are putting to me, and that is what the learned judge herself called the recharacterization of the application that was before her. She found, as you know, that in substance, this was not an application on behalf of the appellants, but on behalf of the legal representatives. See paragraphs 32 to 33 of her judgment. And we submit that this was a fundamental error by her.
What kind of error was it? Factual error?
It was both a formal and a substantive error.
But was it an error of fact or an error of law?
It was an error of law in my submission, my lord. Formally, there was a sealed application notice. For reference, it's at tab 4 of the supplemental bundle. It was issued in the name of the appellants and in these present proceedings. The appellants were the one who sought the relief in the draft order, and that was the application that the learned judge had to determine. What the learned judge did in my submission was effectively to rewrite the application notice, and that, in my submission, she did not have the power to do. But even if, for argument's sake, we accept the premise, there would be an incoherence in what follows in her learned judge, in the learned judge's reasoning.
So what did she rewrote the application? So can we look at the application?
Yes.
What was the application on which you rely, which she shouldn't have rewritten?
The application notice, it's in the supplementary bundle.
Page 22.
Page 20, where we begin.
Which bit did she rewrite?
At the very top of the application, you have a claim number. That is the case which opposes the appellants against the respondent. You have the claimant's name, the appellants are listed there. Those are the parties who bring this application.
Yes. So what did she say? She said it was an
She-
application by the solicitors.
Exactly.
Where?
At paragraph 32 of her judgment, in the core bundle, at tab, beg your pardon, it's in the supplementary bundle at tab 9. I'm getting mixed up. The judgment, tab 7 of the core bundle, apologies.
It's in the judgment, isn't it?
Yes, it's in the
Paragraph 32.
paragraph 32.
Mr. Field argued that although the claimant's lawyers might benefit from the injunction, it's not really being sought for that purpose. Claimants were seeking it to ensure their claims could be properly disposed of, to avoid the legal advice they were receiving from being impeded by the communications. With respect, I can't agree with that characterisation. It's in substance an application for an injunction to prevent the claimant's lawyers from being harassed. Wasn't it that in substance?
My lord, no. In short, if I may,
Was it that at all?
no, it wasn't. We do not rely on the harassment per se. We relied on the effects, or the harassment, I should say. We did not rely on the harassing nature of the conduct. We relied solely on the effects that conduct had for the purpose of those proceedings.
Because it was harassing your solicitors.
Well,
That was the reason it had the effect.
whether or not it was properly characterised as harassment or not in my submission does not matter for these purposes. What we relied upon, and which the judge found, and that goes to the other reason why we say that this was an error, from a substantive perspective, as a matter of evidence, the learned judge found our case made out. The respondent's conduct.
I'm sorry to interrupt,
Yes.
but I just wanted to take you back to the application notice.
Yes.
Section 3 of the application notice, you've drawn attention to who the applicants were. So
Yes.
all the claimants in the action, the company, the two companies and the two individuals. And then Section 3 asks the applicants to tell the court and the opponent what order they're asking the court to make and why.
Yes.
And it tells us what is being sought. But does it tell us why?
It does not. The draft order does.
Right. I'm not sure that I've focused on that.
Tab 7
Thank you.
in the same bundle. Page 142. It's the first recital upon the overriding objective and the court's general case management powers. Currently, that's the reference to 312M, should
Right.
actually now be 312P. There was no reliance on the Protection from Harassment Act 1996.
Well, no, there clearly wasn't, but that's the point.
Yes.
What we're talking about here is the judge's assessment of the purpose,
Yes.
or purposes, of the application. We know what it was for, and we know that your argument was that the aim and objective was to protect the claimants from interference with their conduct of the proceedings.
Yes.
But that doesn't exclude, does it, the fact that on the evidence, what was being complained about was harassment of the legal representatives.
Well,
I mean, that's what all the evidence is about. It only comes from the solicitors, doesn't it?
it comes from the solicitor, certainly.
There's no evidence from any of the claimants themselves, is there?
No, but the solicitors were the ones who could attest to what had practically, in the conduct of the proceedings, what the effect this had. And there is plenty of evidence in Mr. Gailani's affidavit, statement, of the impact that the conduct had on their ability and the disproportionality of the handling these proceedings.
So what is I mean, every piece of litigation, let's take it away from abusive language. In every piece of litigation, defendants raise points, bad points. Sometimes claimants raise bad points and cause their adversaries massive amounts of legal costs, none of which is routinely reimbursed because we have strange orders and strange rules about costs. There's no cause of action to stop people doing things that cost people money in litigation, is there?
My lord, no. Obviously,
Even unreasonably. I mean, you know, the worst that happens is you get indemnity costs at the end of the day, which is what happened in this case.
I was going to say, obviously, there are means with which, through the spectrum of litigious conduct, which the courts obviously deal with in various ways. Now, the issue here was that the judge didn't engage with that, what was range of reasonable litigious conduct. What she said was that radically, I do not have the jurisdiction to deal with this type of interference with the party's legal representatives. Now, I fully accept that one way that this application could have gone, was for the learned judge to say, Mr. Loof, I hear what you're saying, but I don't think that on the factual evidence before me, the conduct is such as to merit or warrant the specific relief that you seek. That would have been, we would have been, I mean, I doubt we would have been here, frankly, if that had been the learned judge's conclusion. The difficulty we have and the reason we are here is because that was not what the learned judge ruled. She did not even engage with on the facts, other than finding that those facts were established. Effectively, what she ruled was that quite apart from the evidential basis of the application, as put by us, was established, there was no jurisdiction for her to make the order sought. And to address square on the specific relief that was sought, my lord,
I mean, can we just look at your, I mean, before we get into these furthest reaches of stuff that is not in any skeleton argument, can we look at your notice of appeal, which I believe contains only one ground? And it says she erred in concluding that she lacked jurisdiction to make the order sought. She should have concluded that the court had jurisdiction to restrain her from abusing, belittling, demeaning or insulting the legal team, or using profane or otherwise grossly offensive language towards them, where such conduct was interfering with the conduct of the proceedings. So, and yet all your skeleton argument was all about the Siskina. But it doesn't justify there being jurisdiction to make an injunction stopping people abusing a legal team or using bad language where it interferes with the conduct of the proceedings. And about that, there is much authority. I mean, that concerns all the cases that deal with interfering with the legal process, which is controlled by the law of contempt and which is controlled by injunctions occasionally being granted. We dealt with some of them in PMC just recently. But that's not the stage that has been set for this case.
I hope, and to the extent that it wasn't clear from the original submissions that we made in the skeleton argument, that we disagreed, obviously, with the basis on which the judgment was made, but also that the proper basis for the jurisdiction is the inherent jurisdiction of the court to control its own process and or jurisdiction under Section 37 of the 1981 Senior Courts Act.
I mean, they are different. Sorry.
I was just wondering, there is a set of principles to do with contempt of court, which is about interfering with the legal process, disrupting the administration of justice, depriving people of their fair trial rights and all the rest of it. You're saying we don't need to worry about those principles because we've got a completely separate, amorphous, I'm being pejorative here deliberately to provoke you, an amorphous principle that whenever there's some interference, that whether or not it's a contempt of court, with the politeness which the King's Bench Guide requires of people, and the cooperative behaviour that it requires of people, then the court can grant an injunction. Is that not too vague and unclear and unprincipled?
I mean, The extent of the jurisdiction that we contend for is now, as we intended for under Wolverhampton, as your lordships have accepted, extremely wide. It deals with effectively where it is open, where a party is properly before the court, and where there is unconscionable conduct.
Well, I think if one looks more carefully at Wolverhampton, it doesn't just say, well, we're equity lawyers. If it's just and convenient in our opinion, then we can grant an injunction. It says quite a lot more than that. And it's also been explained in Abbasi in the way that my lord has mentioned. You start with principle. Once you recognise there's jurisdiction, you need to look for a principle.
Yes.
Usually a principle that's been reflected already in statute, where we've got harassment, or in the common law, or a mixture of the two, which is contempt of court. If you find that those principles don't get you home, is it right to say, well, that's too difficult and I don't want to do that, I'll just resort to the fallback position? Or is that something you only do if you can establish that you've got some legal right that demands to be recognised? And for some reason, the law has failed to give it effect.
May I begin by, and I do this with some trepidation given the bundling difficulties we had, but at paragraph 160 of Wolverhampton, that's page 1043 at letter C. It's internal page 692 of my bundle.
160.
Yes.
Yeah.
What the court there says is that the court there is considering whether the court's practice should be expanded to accommodate new forms of injunction. And what they say is that protection of the court's process from abuse or preservation of the utility of its future orders may fairly be said to be the bedrock of many of equity's forays into new forms of injunction. And that, my lord, addresses, I think, your question, or at least partly addresses your starting point for my Lord Justice Warby's question, whether this is indeed a new form of injunction and whether, if so, the court should endorse it. And it's true that this application was put on the basis that it was an unusual application. The learned judge proceeded on the basis that it was unusual, and she even remarked that she had never made an order of its like again. It is true that it is an unusual, but subsequent research has revealed that it's not unprecedented. In our skeleton argument at paragraph 24, that's a core bundle, page 30, we cite the case of Line Mile Properties, which is in tab 23 of the authorities bundle. It's a property case dealing with a right-of-way over a piggy lane, which led to a property called Eden. And if I can take your lordships to that case.
Right, you'll have to send me a copy of it. I have not got that bundle of authorities, which is why I was so surprised by the authorities bundle, which contained literally not one authority I thought relevant to the outcome of this case.
It has been, it's been sent, the authorities bundle has been sent.
Has it been sent? I'm sorry, you've just got to wait a second because there we go. Thank you. Wants to know the entire history of my life. Right, thank you. I have got it. Maybe I can even download it.
Beg your pardon?
I'm just downloading it.
Great.
Seems jolly big. line mile, I may be able to find otherwise than through there. What's the full name? Line Mile Properties.
Yes. Line Mile Properties and Plater.
And Playfair.
Plater.
Plater.
Yes.
Okay, keep going.
So at paragraph 7, this is on page 598 of the bundle PDF, Mr. Justice Sweeting quotes from the appealed county court judgment, and at paragraph 17 you can glean the background, or the factual background, to the application. It's a section that says, "There is no doubt in my judgment that the claimants are entitled to have their legal advisors come to their property and therefore go across the defendant's land on the right of way without the fear of harassment, threats or assault." And the issue on the appeal in that case is then set out at paragraph 11, which is on page 599 of the bundle. And the issue was whether the learned judge was right to grant an interim injunction relating to individuals and a firm which are not party to this litigation and which does not relate to a cause of action pleaded for determination at trial within this litigation. And my lords, my lady, one does aspire to some originality, but if I can take your lordships, my lady, to paragraph 19 at page 601 of the PDF. The respondents in Line Mile essentially make the arguments that I am making today. And in particular, the last sentence of that paragraph, the fact that the authorities did not include a case when injunction had been ordered to protect a solicitor acting for one of the parties did not mean that the court did not have the power to make such an order, or, in the circumstances of this case, should not have exercised that power. And further in this case addresses another issue which has been raised with me this morning, namely what the true essence of this kind of injunction is. Paragraph 39 at page 605 of the bundle, where Mr. Justice Sweeting finds that it was not a synthetic exercise to disguise an injunction for the benefit of a third party, which was otherwise unobtainable by that party. Both the judgment and the transcript of the hearing show that the judge took care to limit the relief to that which was necessary in the context of the claim. And pausing there, in terms of the specific relief that we sought in this case, and that would be sought in any given case, obviously has to be tailored to the specific conduct which has been found, or which would be found by the trial judge in any given case, has had the impact or the nefarious impact on the good conduct of the proceedings that is contended for. In this case, it was the sort of correspondence that had been emitted by the respondent. In another case, such as in Line Mile Properties, it would be different conduct. And the
Line Mile Properties is a first instance case on completely different facts, which didn't attempt to completely change the law, overriding or without consideration of various modern Supreme Court decisions. I don't think you're going to get very far by saying there's an isolated example of how judges have made a remedy. What we are concerned about is the principled position where there is a legal remedy provided for the people who need to be protected from particular conduct, and you choose to ignore that remedy, as my lord has said, and to fashion a different remedy, which is the inherent jurisdiction of the court to protect its own process. Now, if you're right, and the Harassment Act can simply be bypassed, and anybody can come along and say the way this person is conducting this litigation is belittling, because that's the word you use in your injunction, then that has very far-reaching consequences for the rule of law and the system of justice here. Now, I'm not saying you're wrong, but you won't get that principle out of line mile.
No.
You will get it out of the Supreme Court or the House of Lords or fundamental principle. Now, these questions have been considered at very high level in Convoy Collateral, Wolverhampton, Abbasi, PMC, right, recently. So we know what the jurisdiction is. And I think you need to look at those cases to see what the jurisdiction is that you're relying on. What you're asking us to do is to say that it's in face of Abbasi, paragraphs, I can't remember the paragraphs, 85, 90, it's perfectly okay just to ignore the domestic remedy and go for the inherent jurisdiction. And it's perfectly okay to expand the inherent jurisdiction of the court to protect its own process into this area. Now, for my part at least, I need to be persuaded of that by reference to the highest level authorities that bind me, not, Mr. Justice, with great respect, not a first instance decision on quite different facts. Okay? So,
Yes.
Can we look at what the really significant cases say about whether you can do what you want to do? Because if they don't say that, then the judge may not have been wrong in the way you're alleging.
May I make a general point first in terms of to address the issue of whether there was an equivalent remedy that we should have sought?
Yeah.
It comes back to the issue that I've already raised, in that the factual premise for the application was established. The respondent's conduct had all the negative effects to the appellant's interests that she lists in paragraph 24 of her judgments. So on her own findings, it was not the case that the appellants had merely lent their names, as it were, to an application in which they had no real interest. So that is the fundamental starting premise of our case.
Yes.
Now,
we accept, if it's any comfort to you, we completely accept. The judge found that there were negative effects of the conduct alleged, but proving that there was loss does not prove jurisdiction or the basis on which jurisdiction should be exercised.
My Lord, where I disagree with respect to the characterization that there was an equivalent remedy available is effectively for these reasons. If these circumstances are not remediable at the application of the party to litigation, the risk is that that party will stand without a remedy, because it will leave the decision of whether to address this conduct up to the lawyers acting in their personal capacity. And lawyers in that context may, or indeed I could say will, justifiably be very reticent to institute what would be parallel proceedings in their own names against the self-same defendant.
Same in Abbasi. Exactly the same. The doctors didn't want to bring parallel proceedings for very good reasons, very sound reasons, but it still said what it said. So, of course you're right. There is a very clear distinction between the lawyers defending themselves and the party defending the loss which it has suffered as a result of this conduct. But I still ask you to show me the authority, starting at the beginning before we come to the end, and saying what is the jurisdiction? How is it shown that the inherent jurisdiction of this court to protect its own process allows you to get an injunction not to belittle people, which thereby cause aggravation of costs, let's say, as one obvious consequence? where is that jurisdiction to be found? I need to see it in a case or in an exposition from. I mean, in Abassi and PMC, we explain the jurisdiction to protect the process of the court. I mean, it's in a slightly different context. It's in the context of open justice, but this is all very connected.
Well, Lord, it sounds like we should take time to consider those cases, possibly over the lunch break, and then come back to them, so that I can effectively answer the questions that my Lord is putting to me. The case that we do rely on, another case that we rely on, is the case of Connolly and the DPP, which is at tab 4 of the authorities bundle, page 80.
Yeah.
This is the judgment of Lord Morris, and it's in the context of dealing with criminal matter of auto for acquit. But the principle that Lord Morris states at the top of that page, which is page 1301 of the report, is very broadly stated and must, in my submission, be correct. There can be no doubt that a court which is endowed with a particular jurisdiction has powers which are necessary to enable it to act effectively within such jurisdiction. I would regard them as powers which are inherent in its jurisdiction. A court must enjoy such powers in order to enforce its rules of practice and to suppress any abuse of its process and to defeat any attempted thwarting of its process. And that, in my submission, is the same principles as were built upon by the Supreme Court in Wolverhampton, and which has been relied upon in the first instance decisions which we have referred to, which now appear in our authorities bundle. There's Line Mile, and there is the even more recent case of Wood and Fleming.
That's probably the jurisdiction that enables a court to grant injunctions to prevent conduct which would amount to a contempt of court. The court has an inherent jurisdiction to do what it has to do to make sure that it can do its job, respectively. The job is to adjudicate fairly on cases. The court must be able to prevent interferences with that. Now, normally, contempt of court is exercised as a punitive jurisdiction in its criminal aspect. But there is a rarely exercised but existent jurisdiction to grant an injunction to stop it happening in the first place, which we see exercised in WFZ. The question is whether something that falls short of the standard required to establish contempt of court and to justify an injunction on that basis, that recognised basis, should nonetheless be sufficient to trigger the exercise of this inherent jurisdiction.
The difficulty, this was the topic of, as it were, we addressed this in our supplemental skeleton at paragraphs 15 to 23. There would be some difficulties with transposing the jurisdiction that was recognised or exercised in WFZ to, shall we say, common law interference with administration of justice. It's worth perhaps stating the difference is this, is that when you're dealing with the strict liability rule, as they were in WFZ, you are only dealing with effectively objective criteria. You investigate whether the facts themselves establish a contempt as defined under the 1981 Act. There is no, as it were, investigation into what the intent, the nature of the strict liability rule itself. When you're dealing with a common law criminal contempt, the interference with administration of justice, the court needs to enter into an inquiry, obviously, what the intention behind particular conduct was. What we're saying...
What's the authority for that?
That
you need to
a subjective element.
Establish intent.
I will find the authority.
I think you cited Crosland for that proposition, which I thought was authority for the opposite proposition. So that's an issue to address.
Very well.
the cases I thought said that there is no specific intent required to prove contempt of court by serious interference with the administration of justice. It's enough if you do a deliberate act that does interfere seriously with the administration of justice, knowing that the court is entertaining the case. Now, if that's right, assume that that's right, the point you've just made falls away, doesn't it? And it might be said, if I'm right, that if this respondent's behaviour was serious enough on the evidence to dissuade your clients from conducting their case in the normal way, or to drive them into wholly unacceptable costs, or to drive witnesses away from giving evidence which they would otherwise have done, then the law of contempt would come to your aid. But no one said that.
No, and for the reasons that we relied on the objective impact of the conduct on the proceedings before the court. That
Well,
was
you
the
relied
only-
on evidence from the solicitor, which was principally focused on the impact on the staff of the solicitor's firm, and said that in addition, the conduct was liable to have an impact on the way the litigation was being conducted by the solicitor's clients.
I'm not sure the conjunction in addition follows, but because of the impact of the
That's
solicitors,
just
they
my,
had
my,
the...
my glossing of the
Yes.
evidence. But I'm not trying to... there were two strands to the evidence. One was about how it was affecting the people who were working for the solicitors who were working for the clients.
Yes.
And the other was the impact that that had on the conduct of the litigation.
Yes.
Yeah. But my point is, no one said, as might be the case in some litigation, well, if this carries on, my clients are going to have to give up this claim because it's intolerable. Or if this carries on, we won't be able to get people to give evidence. None of that was said.
No, that's absolutely true. In my submission, that would put a very high threshold to the sort of conduct that would need to be engaged in order to engage the jurisdiction of the court to try to prevent it prospectively.
Well, it is a high threshold. Just what worries me, you see, about this is the sort of impact, if this is right. We all know, maybe you don't, but maybe this is a different level of litigation from that which I'm familiar with, but people are very rude to each other in litigation a lot of the time. One hopes that they aren't. The rules say they shouldn't be, but they are. And if every time someone behaves in a way that is outside the scope of what the King's Bench Guide says is the norm, the other side are going to rush off to court and say we've got to have an injunction to say they mustn't belittle us or demean us, then it's a thin end of the wedge point or a floodgates point. They're not usually very good, those points, as we know. But you see the point that I'm a little worried that we'll get the courts spending a lot of their time managing the behaviour of the parties rather than the issues in the case.
My lord, as I said previously, I think there is properly a matter for appreciation, assuming that the jurisdiction exists, as a matter of power of the court to make the injunction. There is obviously a range of conduct which it would be for that needs to be for the court to appreciate whether it falls within the sort of behaviour that should be deprecated with, for instance, an indemnity costs order, or whether it is so outside of the norm that it needs to be effectively stopped prospectively. Now, my lords, you said that you had seen the materials, the facts themselves. I wonder whether it is worth actually having a look at the messages that were sent.
We've all read Gailani 5, if that's what you're going to take.
Yes,
so
it is.
We've all had a good look at that.
Indeed.
And we've seen what the judge says about it. I don't think anybody's disputing what the judge is saying about it. I mean, it was unacceptable. The issue is the pinhead we're dancing on, isn't it? Is you say it's inherent jurisdiction, but the question to you is: are you entitled to choose inherent jurisdiction over the possibility of both contempt of court and harassment under the Harassment from Protection Act, both of which I think you acknowledge were runners, if you can put it that way. But you choose to do something different. Is that choice open to you or not?
in relation, I think the two remedies that have been raised call for different answers. In terms of the Protection from Harassment Act, for the reasons I have submitted in my submission, then it's not an equivalent in the sense that it leaves the claimants to the litigation effectively without a remedy to deal with behaviour which had an appreciable conduct on their rights.
Yeah.
And say their rights to engage in litigation and to do so with the assistance of legal representatives. Dealing with contempt of court, there is in part an issue of procedural economy. Of course, and in these proceedings that was illustrated, contempt of court proceedings had already been engaged. They were successfully engaged against Ms. Okunola for various breaches of interim orders that had been made as part of the proceedings. This was, shall we put it this way, a less onerous and also less percussive remedy that was sought. In effect, we were asking the court to tell Ms. Okunola, this conduct is unacceptable, and for the future, you will not engage in it. And if you do, there is
there was a penal notice, I think, on the order.
There was a penal notice on the order.
So it was a jeopardy. The jeopardy was imprisonment.
The jeopardy was a civil contempt allegation, yes, with respect to future conduct. I don't know if, my lords, my lady, you wish me to address individually or expressly the questions that were put to me yesterday.
You have to take your own course.
Yes.
But we have indicated in different ways, but pretty much the same point from each of us. The problem here is jurisdiction. And the jurisdiction to grant an injunction that restrains belittling or demeaning on the grounds of an inherent jurisdiction to protect proceedings is one that is new to me, right? And when you have a perfectly good statutory remedy to protect something which is known, namely harassment, Lord Sumption said in 2013 what harassment meant, that it was a plain English word. Everybody knew what it was. If you injunct somebody from harassing somebody else, they know what they're not supposed to do. I am not sure it is the same with belittling or demeaning, and I'm not sure that belittling or demeaning is something the courts regularly stop people doing in the context of and in order to protect the integrity of legal proceedings. Now, if you say that's wrong, which I think you do, and you say that there must be a remedy in the parties to the action to stop them having to incur costs and having to suffer belittling and demeaning, and you persist in wanting an injunction to stop Ms. Okunola belittling and demeaning your client's solicitors, then you're going to have to show us the cases that give you jurisdiction in the face of a BASI, in the face of PMC, and in the face of a clear understanding of what that inherent jurisdiction is, what the jurisdiction for contempt can prevent. Because litigation is something, as the cases my lord drew to your attention yesterday shows, litigation is an environment of hostility in which there are protections for that environment to allow people to say what they want. Now, of course, my lady is right. What happened here, I don't think there's any real dispute, unless Ms. Okunola wants to say to the contrary. Some of the language used was totally unacceptable. What was being said was outside the normal parameters of what I've indicated is the hostility of litigation. But we still have to get to grips with, is this the right way to do it? And to do that, you have to persuade us that the jurisdiction extends as far as you say, and that the hurdle, the high threshold the court has referred to, is reached. and when there are other remedies available. And Abbasi speaks to that. In the words of Lord Reed, who, we need to listen to in this court. And he speaks very eloquently about it. So if we look at Abbasi, we'll be able to be moving further forward. If we don't, we won't, I think. You can go to any number of first instance decisions which won't help us if we've got the benefit of the Supreme Court.
Also, beg the court's forgiveness, I haven't got a Abbasi in front of me and I'm not ready to make submissions on that. So I will.
Well, I wonder if it would be helpful. I mean, you've heard what we said. The advocate to the court has heard what we say. We're troubled by this case. It raises really important issues, right? And it's very much on the reason we're here with this court is that it's obviously important. It raises questions of free speech, and it raises a new point about the extent of the inherent jurisdiction of the court to protect the process of litigation. But you can't start at the end and work back to the beginning. You have to start with jurisdiction and then look at how that jurisdiction is exercised and look at all possible available jurisdictional foundations. And I'm at the moment in doubt whether that process has been followed, really, and whether you've been looking at the right authorities. I said, slightly joking, but nearly seriously, that the first 4 bundles of authorities I was given did not contain one case. I think there was one that I thought was marginally relevant, but there weren't many. But there are relevant authorities if this is your case, namely that this jurisdiction, to protect the integrity of legal proceedings, should go as far as you say to get an injunction in these very subjective terms. If you're right, we absolutely want to listen to your argument, but we do want it founded on the correct authoritative base. So would it be a good idea for you to spend 15 minutes just thinking with your clients about what's been said? I don't know whether my lord or my lady want to add anything to that.
No, thank you.
Is that a good idea?
I will accept that invitation.
Think how you want to proceed. I mean, one possibility is for you to apply to adjourn this appeal so you can reconsider the way you put it and look at some of the authorities that we think are relevant but you previously didn't. Another possibility is to regroup at 2 o'clock if that's really, if the time allows that. There's all sorts of things that can be done. I mean, we understand your argument now better than I think we did before. We know that you say this is a claim by your clients. It's not a claim by the solicitors. We do not wish to bring a harassment claim by the solicitors, and we should have our own course of action, and it is under the inherent jurisdiction of the court. So we're not, if you like, undermining the basis on which you put the appeal, and we've seen your notice of appeal. It seems to me anyway to be open to you to say that on the basis of your notice of appeal. But you can't ignore modern authority in arguing that. Okay? So we'll rise for, should we say, 15 minutes, if that's helpful, just for you to think about what you want to do.
Yes, and then we will indicate.
Then you can indicate what you want to do. I mean, if you want us to come back earlier, just send a message.
I will.
All right. We'll sit again at 10. Yes, Mr. Liv.
Lords, my lady, I'm grateful for the time to consider. We have been able to consider, at least outline, the issues that were addressed in Abbasi and PNC. And while I can see the outline of the submissions that I would like to make on those two cases, I am not, as I stand, in a position to give the court the sort of detailed assistance which I take that the court requires on these authorities specifically. And in light of that, we would seek the adjournment that my Lord Master of the Rolls floated earlier during the hearing. It would be to enable us, obviously, to assist the court on a matter which the court itself has indicated is of general importance. I have conferred with the advocate for the court. I will not speak for Mr. Doggle myself, but I'm sure he will have submissions to make in relation to this.
Shall we ask what Ms. Okunola thinks first? What do you think, Ms. Okunola?
Will the adjournment, how long are they looking to adjourn? Is this
Well, it'll have to be fixed whenever this court is available, which is likely to be 3 to 6 months.
I think that they should have been more prepared and should go ahead.
That's a very fair point, Ms. Okunola. But the reason why an adjournment is needed is because this court can't decide on such issues of really great importance to the litigation community without full argument. And in a moment I shall try and direct Mr. Loof and indeed you towards the issues that are really concerning, so that we don't have a similar situation next time. But thank you for your point. Yes, Mr.
My Lord, first may I apologise to the court for not anticipating the points in the cases that you asked quite rightly for submissions upon today, and I apologise to the court. I hear what my learned friend says about PMC and Abbasi, and likewise I wouldn't be in the position to provide detailed assistance on those today, and I'm in your hands. Third, I hear, my Lord, the very helpful indication you have just given that you would be setting out the points on which you wish to have assistance. And for my part, it strikes me, hearing the discussion today, that there are in effect 3 points, of which I've really only concentrated in preparation on one. The first is whether the High Court has power to make an injunction against a party restraining them from unconscionable conduct to another party's solicitors. And on that question, I was going to address you today by reference to Wolverhampton, both by reference to the narrow strict power point and by reference to the principles by which that power is exercised, which are set out in the Wolverhampton judgment. Secondly, though, it's readily apparent that the court is concerned with the question of whether the potential availability of an alternative basis for injunctive relief is a reason either precluding the power referred to in question 1 or why it shouldn't be exercised. And I was going to address you on that today, but that may be for another day. I think the short point I was going to make was, in effect, that there may be a distinction between an order that is ancillary to proceedings directly before the court, and, for example, the relief of a final injunctive order in a 1997 Act harassment claim, and there may be reasons by reference to the overriding objective why, if there's unconscionable behaviour that the court is appraised of, it would be not inappropriate for it to take action there rather than require further claims or amendments of claims and so on. And then the third issue is the threshold question, if there is the power, and if the question to the potential availability is not always such as to preclude the exercise of that power. And that threshold question raises, as my lord, in a sense, put to my learned friend, well, this order seeks to restrain belittling behaviour, demeaning behaviour. Now, as I say, that there may be a threshold question if the order is drafted in such a way as to prevent unconscionable behaviour. There may be drafting points there, but respectfully, I think that the threshold question is a further distinct point, because I confess I read Mrs. Justice Hill's judgment and read the words threatening and sexually abusive content, and worked in effect on the basis that if the conduct was found to be unconscionable, would that provide a basis for an ancillary injunction? And related perhaps to the threshold questions, or all those questions, is in a sense the temporal question. I realise I'm developing it further, but obviously one of the points in Abassi was about the extension of the injunctions beyond the litigation that gave rise to them. And effectively what I suppose grasping at here is that there may be a distinction between a Prohibition of Harassment Act injunction, which you get a final injunction not to be subject to a course of conduct amounting to harassment into the future, and a position where the court, of its own motion or on the application of a party, says, well, the conduct that the court is appraised of can't continue during these proceedings because it interferes with the administration of justice of these proceedings, but it is ancillary to the proceedings and limited to them. And that is obviously the point that Mr. Justice Sweeting was making in the Line Mail case. So, my lord, I would be very grateful for adjournment. I do apologise to the court for not anticipating both the cases you quite rightly refer us to.
Well, thank you very much. Good. Well, thank you all. We propose, in the exceptional circumstances of this case, to grant an adjournment of this appeal to be refixed as soon as possible before this same tribunal, but there will need to be some things done in the interim period. First, it will be necessary for the appellants to consider whether they wish to amend their notice of appeal, and if they do, to apply to the court to amend the notice of appeal. Secondly, there will, after that has been gone through, it will be necessary for there to be further skeletons filed by all parties, including the advocate, to the court. We propose in the first place to send you in writing the concerns we have and the points on which we think argument must be addressed before the case can fairly and justly be decided. What I'm now going to say is just to give you as clear as I can, add on the hoof exposition of why I think, anyway, that the case needs to be adjourned. First, this case has very significant repercussions for the conduct of litigation. It is not an isolated incident for parties to behave in a hostile, aggressive, and even unconscionable manner in litigation. And that has been the subject of the SLAPS legislation. It raises questions that bring into question the law of contempt, the law of defamation, and the jurisdiction on which injunctions are to be granted. Now, we have fully understood the reason why the appellants in this case wish to advance the case, that they should be able to get an injunction to protect their solicitors so as to protect them from running up costs in the litigation and having to face unconscionable conduct or abuse. But that is a new form of injunction, as has been demonstrated by the words used in the language of the order sought, namely subjective words like belittling and abusing and demeaning, as opposed to slightly more objective words like harassment. So it seems to us, or it seems to me anyway, as I said, that we need argument on the jurisdiction to grant such an injunction when there is a jurisdiction under the harassment legislation, and that calls into question the breadth of the inherent jurisdiction of the court, which is undoubted and is explored in all the cases mentioned this morning: Wolverhampton, Convoy Collateral, Wolverhampton, Abbasi, PMC, as to the nature of the jurisdiction of the court to protect its own process. But it also calls into question Article 10, as that applies to that inherent jurisdiction, and it also calls into question the law of contempt, and as my lord has pointed out, the scope of the harassment legislation, whether the harassment legislation actually allows a claim to be brought to protect third parties. And that is a moot point at the moment, or a question at least, on which argument is needed. It's not obvious. It also calls into question the other point my lord raised, which is the question of immunity from suit when you do something in the context of litigation. What is the extent of that immunity? Does it have any bearing on the inherent jurisdiction that I've mentioned? And all of this, of course, is in the context of making sure that people can litigate fairly and properly, and not hindered, but equally that there are not unreasonable fetters on the parties' conduct within the litigation to say broadly what they want about others, because that's the litigation process itself. So it can be seen from what I've said that the scope, unfortunately, of the argument in this case must be wide-ranging. Now, you have obviously decided, the appellants have obviously decided they wish to pursue this appeal, notwithstanding that the case is over. I agree there's enforcement and everything else about it. And that sounds very public spirited to me because these issues have not been raised before, so far as I'm aware. But we must have argument on this, where Line Mile, for example, is going in the context of the other authorities we've mentioned. And actually, if you go back in the history that I traced through in PMC, only in a judgment in August, you'll see that there is much said about the protection of the litigation process in cases following Scott and Scott, right up to Abassi and PMC itself. So there's quite a bit of work, it seems to me, for you to do. I think it would be quite inappropriate for this court to decide a case of this importance without full argument. So we're delighted we've got an advocate to the court, because we would have needed an advocate to the court at this stage, even if we hadn't had one before. So Mr. Donmar, we entirely accept your apology, and we hope that you will be able to help us on all these points. So to summarise, subject to anything any of you would want to say, 2 days? 2 days, yes. We're going to adjourn this case to come on at a date to be fixed before the same tribunal, if at all possible. Of course, if not possible, it's not possible. But if at all possible, before the same tribunal with a time estimate of 2 days. The court will summarise what I've just said and anything else that occurs to us in writing to the court, hopefully to the parties, hopefully by the end of the week, so as to guide your thoughts on what argument we need. You will then consider whether you want to apply to amend your notice of appeal. It'll be open to you, Ms. Okunola, to oppose if you wish to, because it's late and you can say what you've rightly said, that they could have done their homework better in advance. But nonetheless, don't let that dissuade you, Mr. Loof, from considering what needs to be in your notice of appeal. We would like to know perhaps also an update on the current position. There's one line in your skeleton that says this behaviour is continuing. I would like to know anyway, for my part, what is continuing, what the current position is, and I would give you permission to file some up-to-date evidence on that, and Ms. Okunola to reply, only because you're continuing to ask for the injunction. And by way of timetable, I would suggest amended notice of appeal within 21 days. Give you 21 days to submit an application for the amended notice of appeal. Response to that really should be in 7 days, because it's not going to be very substantial. And when you get the decision on the amended notice of appeal, if there is one, can we have skeleton arguments within 21 days from the appellants, and Ms. Okunola, you can exchange skeleton arguments 21 days after that, and the advocate to the court can have a further 14 days after that. So I think it's looking like next year, but it would be next year anyway. Could you, counsel, please reduce that order into writing for our approval?
Certainly, yes.
Anything else?
Can I add my apologies to those of Mr. Dornmore that we weren't in a position to do what we intended to do this morning?
Yes, well, it's difficult. It's as we've looked at it, as you see, we've come up with points every day as well, and put them to you as quickly as we could. But it's a difficult case and potentially an important case. So we would be doing everybody a disservice if we didn't do what we're doing now. Thank you.
Jeffrey,
Grateful.
can we add to the directions, please, that you will look again at the joint bundle of authorities, and can we have them in a version that works electronically when they come back in? And it may be we can omit. We can start again, perhaps, on the authorities.
What sometimes has to happen if you encounter the problem you've had with the CE file, is that someone somewhere has to assemble them all into a single document and convey it by some other means. I've done it at this end. It's not a complicated thing, but it really does help to have the electronic tabs.
It certainly does.
Would you like a direction as to when the joint authority bundle should be submitted? Should we have that 14 days after the skeletons from the advocate of the court, or?
You can agree directions on it. Good. Thank you very much.